claim that Indian First Nations might have had to their lands and territories, then the process is completely different, because you start off with the assumption that the land is owned by the Crown, that the sovereign title to the land belongs to the Crown. And so when you enter into a relationship with Indian people, and Indian people succeed in those negotiations in getting land allocated for their use, their exclusive use, and they succeed in getting resources and other benefits. From that perspective, you see the claim from a different basis. It's a case where Indians are receiving. It's a case where Indians are seen as having their hands out and depending on the largesse or goodness of the nation state or the Crown. And so, because of these two diametrically opposed or contradictory viewpoints, you have had a lot of confusion on the question of Indian claims, how they are resolved or how they ought to be resolved. A lot of ordinary Canadians, when they deal with or hear about Indian claims, because all of the historical institutions within the country have predicated their assumptions that the original title to the land belongs with the modern nation state or the sovereign or the Crown. They have operated on the belief that the only right that Indians have recognized over a long time is a very limited use, personal use right over the lands and territories that they occupy. So they have a little bit of a claim recognized by law over the years, but it's nothing equal to the ownership, to the title that the sovereign has, the sovereign jurisdiction, the sovereign ownership over lands and territories. And when the Canadian government wants to deal with resolving Indian claims, it's resolving that narrow, limited right that they think Indians have over their lands and territories. So in order that the Crown will have clear title to the land over which it claims jurisdiction, it enters into an agreement with Indians that are called treaties, or in the modern context, they're now called modern settlements, where that process is viewed as one where the Crown gives to Indians lands, resources, and other benefits. And that perspective, I think, in turn creates sometimes some resentments within the white community, because many white people, particularly those that may be undergoing severe economic hardships at various times in Canadian history, wonder why Indians are getting everything for nothing from the Canadian government and why they're not. And I think in part that kind of a perspective, or why that perspective arises in this country, is directly related to how you answer the question of who owns Canada, the kind of ownership that entity has over the lands and territories in Canada. And of course, from the Indian side, where ownership is looked at, sovereign ownership and jurisdiction is looked at as being within the hands of the Indian First Nations. The question or the viewpoint is when it comes to the settlement of Indian claims is not what Canada is giving to Indian people, but what Indian peoples are giving or sharing with Canada. And I think as long as there isn't a bridging of those two viewpoints, and as long as that issue is not resolved in a manner that is fair and just to all people in this country, we're going to continue to have the difficulties surrounding the question of Indian claims in this country. So I wanted to give that kind of general background prior to dealing with the current situation as it exists in Canada on the question of Indian claims. I would like you to remember that it is not that long ago that we saw the razor wire strung around the community of Kanesatake over the question of unresolved Indian claims. And as we look across the country, I doubt that the situation will have very much improved until this point in terms of the resolution of Indian claims, because there is no indication of any movement to try and bring about a satisfactory resolution to some of the more fundamental questions that underlie the question or the matter of Indian claims in this country. Now, having said that, I think for a number of years, at least from the 1920s to perhaps the 1970s, we had a kind of policy hiatus in Canada at the governmental level in dealing with the question of Indian claims. And the hiatus was brought about, I think, in large part because with the signing of the last treaty in 1921 or thereabouts, the government of Canada probably believed that it had extinguished all Aboriginal title in the country, or at least it didn't have to go any further than it did at that point. And so nothing happened, and I guess until the late 1950s, the early 60s, mid-60s, there was some discussion within government circles that outstanding Indian claims ought to be resolved. And in the late 1960s, there were, in fact, two proposals submitted to the Parliament of Canada for the formation of an Indian Claims Commission. And what that would have required, if it had been approved at that point, would have been legislation and the establishment of a commission that would examine the question of Indian claims in the country. Well, in 1969, that whole process came to a sudden screeching halt, so to speak, with the introduction of the 1969 white paper on Indian policy put out by the Trudeau government of the day. And what the government said in 1969 on the question of Indian claims is, look, forget about Indian claims, really. The best hope that Indians have in this country is if they become citizens like everyone else, where they have no special rights, and where they're treated as any other person. The whole concept of equality, that is the best hope for Indians in this country. And so they said in 1969, we're not going to deal with claims arising out of Aboriginal title because those claims are so broad, so general, they can't be resolved. They said, when we look at treaties, we look at the terms of the treaty, we look at the words, we examine the documents themselves, And they kind of patted themselves on the back in 1969, and they said, we did a pretty good job of observing the treaty obligations we had. And in fact, if you look at what the treaties promised and what government programs have delivered, we've gone far beyond what was ever contemplated by the treaties. We've given Indians much more than what was promised them in treaties. The only thing we're prepared to admit, they said in 1969 in their white paper, was that in a few areas in the northern parts of the provinces, we, as per our treaty commitment, did not set aside the lands that were called for under treaty for the creation of reserves. And so they said, and there may be a few other odds and ends that we can deal with. By and large, we're satisfied that we fulfill the treaty obligations, except for these few limited areas. And we're prepared, as part of winding down Indian status, to settle these limited questions. And so from that a portion of the 1969 white paper, you had the birth of what is known today as the specific claims policy. And so you will note, in terms of government policy, that in 1969, in a very clear and concise manner, the government said that it was prepared to deal only with a limited amount of claims arising from treaties where it could be clearly demonstrated that those terms had not been completed. They would not deal with comprehensive claims, and they would not deal with Indian claims arising from any treaties signed before Canadian Confederation. And the policy statement of 1969 was also very limited in the sense that they said when it comes to the treaties, if we're going to examine any claim from the treaties, it's got to be based on the words as we see them. We give a literal interpretation to the treaties. Nothing more than what is in the terms. We're not going to look at any documents that pertain to that particular period. All we're going to do is look at the words as they are. And that concept was described in a phrase that they call lawful obligation. And so in 1969, of course, that policy paper was not accepted by Indian people in this country. And the claims, particularly the claims policy as it was emerging in 1969, was totally rejected. However, that did not stop the government from advancing its claims policy position on the basis outlined in 1969. In 1981, or prior to 1981, the Nisga'a people in British Columbia had gone to court on the question of Aboriginal title or Aboriginal rights that they would have to their lands and territories. If you remember, in 1969, the government had said clearly and specifically in its white paper that it would not deal with comprehensive claims because they were too vague in general. The Nisga'a case, which went before the Supreme Court of Canada, established that the Indians had some kind of Aboriginal title. And the Supreme Court of Canada had come out in a tie on that particular issue. And so the government of the day, in fact, Prime Minister Trudeau at that time, responded to the Nisga'a decision of the Supreme Court of Canada saying, well, maybe in 1969 we were too hasty in stating that Aboriginal claims were too general to be resolved. And so they did a mini reversal on that particular aspect. And in 1981, they came up, or in 1973, I'm sorry. In 1973, the government introduced a mini revision of its 1969 policy. They were careful to say that the specific claims policy would remain as is, it wouldn't alter, but that given the developments in the courts, they were prepared to begin dealing with comprehensive land claims in Canada. And of course, from that period of time, you had the situation going on in northern Quebec with the construction of the hydro project and the eventual emergence of a modern treaty or a settlement called the James Bay Agreement. And I guess the James Bay Agreement represents the first agreement negotiated under the comprehensive land claims policy adopted by the federal government. In 1981, the other thing, though, that remained constant from 1969, before I moved to 1981, is that with the 1973 amendments introduced by the government accepting comprehensive land claims, they maintained the position that pre-Confederation or claims based on pre-Confederation treaties would not be dealt with. In 1981, because there was so much criticism by Indian people and so little movement in resolving Indian claims, some further revisions were made to the specific land claims policy. But by and large, and again you will find in 1987 a further revision of the claims policies, both specific and comprehensive. And in 1990, you will find the most recent statement was that delivered by Prime Minister Mulroney in Vancouver in the spring of 1991, announcing some further loosening up of the processes outlined in the specific claims policy. I would suggest that you take a close look at the policy documents which form part and parcel of your reading list to examine how the specific claims policy and how the comprehensive claims policy work in a mechanical sense. I think in a general way, you can make note that in 1991, with the Vancouver statement by Mulroney, that the current policy of the Canadian government in dealing with Indian claims now includes any claims arising from pre-Confederation or prior to 1867. Now, what happens if you look at the country in terms of the claims that the Canadian government was prepared to deal with, and again, I put the caveat, I'm not accepting the definition of claims or even the version of claims that the Canadian government puts out. I guess what I'm doing now is to try and describe what the mechanics are in place. But if you look at the claims policies as they emerged from 1969, and I think fairly quickly what we should do is just examine some timing, some timelines. I believe you'll find in 1763, with the Royal Proclamation, that the British monarch of the day had outlined a process which has come to be known as the treaty-making process. What the treaty-making process did was to set out rules governing how Indian lands and territories are to be transmitted or given out. It was very clear from the treaty-making process that Indians could not sell their lands directly to white people as individuals or to nations other than Great Britain. What the treaty-making process required was that the Indian nations enter into formal public negotiations with the Crown, and they would then transfer the ownership or the title that they had over the Crown through this treaty-making process. And that process has continued in a consistent manner from that time and even before that, with the negotiation of various treaties across the country. And that continues to be the basis for the negotiation of treaties today. And so if you look at the policy as it emerged in 1969, and I guess in 1987 there was a clear policy statement by the Canadian government that they were picking up, revamping the treaty-making process as a process of dealing with comprehensive land claims. You will find that in 1969 that Eastern Indians living in Eastern Canada had no recourse, in effect, no recourse to solving any claims that they had arising from the treaty agreements that they negotiated. That in 1969, in effect, the only claims the government was prepared to look at were those claims arising out of treaties negotiated in Ontario and the prairies after 1867, and that as a consequence, you'd have BC, Canada's north, and Atlantic Canada excluded or frozen out of the claims process. And what has happened up to 1991 with the various amendments made to the claims policy is that now one can say for the first time that Indians across the country perhaps have an opportunity to be able to talk with or negotiate with government representatives on any claims that they may have, but there are very strong limitations to that. By way of government policy, taking both the specific and comprehensive claims policies of the Canadian government, the mechanics or the procedure for dealing with Indian claims are laid out in the government policy documents, and if you get the most recent revision, you'll be up to date in terms of how you file a claim, what you have to do to document that claim, what kind of information you have to get. And in a fairly quick way, all I will say at this point is that any Indian claim has to be submitted to the Minister of Indian Affairs, who then will either validate or not validate the claim, and if there's validation, then authorizes the negotiations to commence for the resolution of that particular claim. The difficulty with that particular process and the objections that many have raised from 1969 through the present time is that the negotiating process, the policy framework set out by the Canadian government is arbitrary. It's one-sided. It gives complete power to the Minister of Indian Affairs and to his department, in effect, to do as they want, to do as they please with any claim that is brought before them, with very little recourse left for Indian people. Where claims, another way that Indian people can deal with their claims is through the courts, but to date there has been some concern that process may not bring about the kind of just resolution required as well. And so I think one will find, because of the many problems that have been associated with Indian claims in this country, that the resolution of claims by Indian people will by and large continue to remain unresolved and perhaps unresolvable as long as there is not in place a mechanism that Indian people can have faith in, that mechanism will yield just and equitable results for the Indian people in this country. I think probably I should think of bringing this particular lecture on a close at that particular point. I would have liked to cover a number of other areas related to Indian claims. I'd like to suggest, however, that you look at, in a very close way, the policy statements that have been released by the Canadian government. And there are two other sources that I'd like you to review, because I think those outline in a very clear way the kind of problems that are inherent with the present process as it's established, and that is the reports that have been released by Commissioner Wright here in Saskatchewan and by the Ontario Indian Commission. Thank you.
Good evening and welcome once again. Now it's Part B, and the title for this Part B will be An Introduction to the Concept of Self-Government. We will, and I'm going to use a new word tonight, we will not cover three issues, we will uncover them. I feel that's more appropriate. Usually we say, a professor says, an instructor says, tonight we will cover such. I think we will uncover them and we'll look what's there. Okay. The three issues we will address under self-government are: one, definitions, B, options, and C, the constitutional talks, or the Constitution conferences. And you see that on your monitor. The definitions will deal with various aspects and factors that shape up the concept of self-government. Self-government is a very complicated issue. Let's look then at some of these factors about self-government. To the native people of Canada, the first thing, self-government is an aboriginal right that was never surrendered. That's the bottom line. Self-government is an aboriginal right that was never surrendered. As Professor Cardinal just mentioned in Part A, recent research demonstrates that Indian people did indeed occupy and use the land prior to contact with the Europeans. Bottom line again, that Indian people did indeed occupy and use the land prior to European contact. And he also, Professor Cardinal also stated about the Royal Proclamation, that the British law said that the rights of colonized people continued to exist until they were explicitly taken away. And in the case of the Royal Proclamation, only the British Crown could do so. I encourage you to go back to the Royal Proclamation, as I said last week. That's a very key document. And look at it in the context of treaties, look at it in the context of land claims, look at it in the context of self-government. It's not just a one-shot deal document type and that's it, and then you put it aside. That's a document that applies itself throughout the course and sheds light on various issues. Excuse me. Where is it? Here it is. Another issue is Indian bands and nations governed themselves before the arrival of the European. Indian nations governed themselves before the arrival of the Europeans. And that self-government expresses itself from the formal consensus of a small Indian band to the larger tribal representation of the Six Nation or the Northwest Coast Indians. You had small consensus of an Indian band. That was their self-government way of doing things. Then you also have the more complicated representations, tribal representations of decision-making as illustrated in the Six Nations or the Northwest Coast Indians. So you had those. The Canadian and British government, another point, took away these powers from the Indian people. The power of Indian people were replaced by the powers of the Indian Act. The Indian Act deposed the chiefs, replaced their traditional government structures with band government. The traditional government structures of the Indian people was replaced with the elective band structures. And with the help of administrators and Indian agents, the Indian Act made rules to control nearly every aspect of the daily life of Indians. Nothing new here. Another aspect of the definition, the traditional form of self-government existed with their own style of leadership and of decision-making. And I repeat, traditional form of self-government, the traditional form, existed with their own style of leadership and of decision-making. On page 236 in your textbook, I would like to read an excerpt from Marie Marulé. In traditional Indian societies, whether band or clan, authority was a collective right that could be temporarily delegated to a leader under restrictive conditions to carry out essential activities. But the responsibility and authority always remained with the people. In situations where the collectivity temporarily delegated authority to a leader, that person had to have the respect of the entire tribe, not merely the support of the majority of votes. Obedience to the leader derived from the respect that the people had for the leader. Marie Marulé I've worked with her on the committee that helped form the World Council of Indigenous People in Georgetown, Guyana in 1974, along with George Manuel, Omer Peters. Those two have died and passed on to the great powwow on top there. And Marie Marule and Clive Linklater were the four people with the National Indian Brotherhood at that time who were instrumental in organizing the World Council of Indigenous People, an issue that we will see later on as one of the contemporary issues. Leaders were not expected to make their own decisions on behalf of their people. Rather, decisions were made by the people through their leaders. A little bit of distinction here. Authority came from the band and not from the leader. So much so, in a very broad way, we can say that the definition, an Indian leader said that one definition of self-government is a right inherited from Aboriginal law. Self-government is a right inherited from Aboriginal law that recognizes the group's right to participate in decision-making. Self-government denotes also several other concepts. Some of the questions are, does it mean Indian nations have the right to create sovereign nations and to create their own laws, independent of the existing state, such as Canada? Is that what self-government means? Create sovereign nations? Another question, does it mean that they can continue to self-determine themselves as Indians under the general Canadian laws? Perhaps with some self-governing institutions of their own, such as health, education, and justice system. These are key questions that are being asked. The federal and provincial governments have not shown a willingness to extend self-government to sovereignty. The governments at both levels, the federal and the provincial, cannot envision a system of government which recognizes an independent nation residing within a nation. And that is, and I will write this on the board, concept of sovereignty. Sovereignty. I always have trouble writing that word. Sovereignty. That's when an independent nation resides within a nation. An independent nation resides within a nation. No government is willing to give this to the Indians or to the Aboriginal people. However, those same two levels of government, the provincial and the federal, are prepared to acknowledge self-government as self-determination. Self-determination. What does that mean? Self-determination means the delegation by the government of an authority, the delegation by the government of authority to run institutions central to self-government. As I mentioned before, could be education, could be health, could be justice, so on. Can you see the difference between the two? Governments are willing to negotiate this, but not that. In between these versions of, let's say, self-government, we can find various models that give more or less power and authority to native people. So the proposals or the models of self-government range from total sovereignty, that is, the Indians would become independent states within the state of Canada, to the basic right of self-determination within the state, or even under the state, under the control of, and that control has to be qualified. As we go along here, this might be confusing at this time, and you probably have questions to ask. That's normal, because this is not an easy issue to deal with. Be patient and follow the development of this lecture. Who are the players involved in the search for self-government? There's the federal government. There's the provinces. The federal government, history tells us the role and responsibility of the federal government. There is a special government document that tells us that. Do you remember which one? The British North American Act tells us about the federal government's responsibility to Indians and lands reserved to Indians. Remember the paper by Tobias in the first term, how the policy towards Indian people have changed from what Tobias called assimilation and protection. And that has changed, that policy has changed from assimilation and protection to what we call today self-determination. The government no longer tries to assimilate Indians, no longer tries to protect them, so to speak, but does recognize their right to self-determination. But it's the way that that's going to be exercised. Just like Quebec wants to be a sovereign state with distinct society within Canada, maybe with economic links. Huh? Okay? There's a lot of issues. The provinces, they've never been anxious to take away responsibility for status Indians away from the federal government. However, the provinces have had some responsibility for Métis and non-status people. But generally, if we look at the record, these Métis and non-status people have the same status as any other citizen, even though they are recognized as Aboriginal people. Furthermore, not all provinces think the same. New Brunswick, Ontario, Manitoba have shown more willingness to recognize Aboriginal rights than have Saskatchewan, Alberta, or BC. For example, Ontario and some other provinces have worked with Native organizations in supporting Native delivery of child welfare services, policing, language development, and economic programs. Yes. You have the federal government with all its policies, and then you have each province, and they come up with their own policies regarding self-government. And they even don't agree among themselves. What about the native organizations themselves? These are other players, key players in this negotiation. We talk about the federal government and Indian affairs, and then we talk about the provinces. They have their own priorities. They have their own views on what perhaps self-government should be for Indian people. What about the other groups? Okay, let's take a look at the native organizations. They've always played a key role in representing the native populations in their dealings with the government. Native organizations have grown both in strength and in numbers, membership, focusing on regional and national issues. The Inuit, for example, represent the Inuit both regionally and nationally. They were very vocal at all constitutional conferences. And some of the issues they put forward were Aboriginal rights, title to the land, shares in non-renewable resources, self-government, communication with the North, health issues in the North. These were some very key areas that the Inuit organization brought to the forefront in negotiating with the federal government. However, unlike the native groups in the south, Inuit form a majority on their northern lands. And they want to achieve a provincial-like jurisdiction over part of the territory. And their proposal is called, the Inuit proposal, do some of you know this? What it's called? It came out in the news about 3 weeks ago when they divided the proposal to divide the Northwest Territories, East and West. What is the East called? Nunavut. Yeah, Nunavut. This would be a public type of government for the Inuit people, not an ethnically based government. In other words, it would protect the rights of all the citizens. So you see that there is a difference in the way that the Inuit approach self-government, because they do have a consolidation landmass in the north compared to the southern groups whose population is all over the southern parts in little pockets here and there. While in the north, the Inuit have this big consolidation landmass. What about the Métis? They were first represented by a national organization in 1970 by the Native Council of Canada. I was present at that founding meeting representing the Manitoba Métis Federation with our leader Angus Spence. May he rest in peace. He died of cancer a few years ago. He was then the president of the Manitoba Métis Federation. In 1983, the Métis were also represented by the Métis National Council. They identified the Métis of the Western provinces, who identified their origin and descendants at Red River in Manitoba under Louis Riel. The Métis have never been a federal responsibility. Since 1982 in the Constitution Act, they've been recognized as an Aboriginal people, and since that time they've been trying to establish some mechanism to negotiate land and self-government with the federal government. The Métis National Council, for example, asserts that the Métis born of Red River have a continuing right to exist as a nation, as they first proclaimed in Manitoba in 1870, when Manitoba entered Confederation under Louis Riel and the Métis. And as you know, important Métis land claims are presently going on in Manitoba. The Métis land rights in Manitoba will be the topic of a forthcoming class. It is the non-status Indians who are in the most precarious, uncertain, insecure position. They have no reserves and seem to fall between the Métis and the status Indian groups. What about then the Indian groups? At first there were two groups representing the status Indians. The National Indian Brotherhood until 1981, and from then on until today, the Assembly of First Nations. Their position on Aboriginal rights remain firm. Aboriginal rights are inherent rights. They cannot be delegated by any government. And that the legal responsibility for implementing those rights lies not with the provincial government, but with the federal government, as explained in the Royal Proclamation. People like Harold Cardinal, for example, will call this Royal Proclamation the Magna Carta of the Indian people, recognizing Aboriginal title to the land. And also the other one, as I mentioned before, the British North American Act, which is really Canada's first constitution. It recognizes the federal government responsibility towards Indians and towards Indian lands. So we looked at some of the aspects of self-government, an introduction, definitions, from sovereignty to self-determination, really. Let's look at some of the options. That's the B part, or the second part, according to our module. First was definition, now we're at options. And for the sake of clarity, let us imagine that the search for self-government is a game of strategy, like any political game. Politics is a game of strategy, involving several different players, as we have seen. Federal government, especially the Indian Affairs Department, provincial government and several of their departments, native organization including Inuit, Métis, and Indian groups. Each player has distinctive objectives and separate stakes or interests. What are some of the possibilities for self-government? What are some of these options? First one is the top-down strategy. Top-down strategy. Amend the Constitution in such a way that the right to self-government is clearly defined. Amend the Constitution in such a way that the right to self-government is clearly defined. And this would guarantee that other legislation, whether federal or provincial, would not interfere with the right of Aboriginal people to govern themselves. The specific terms and working agreements can be worked out among the players. Very interesting option, the top-down strategy. That doesn't mean it's being imposed from the top, no. But that's the way it's being worked out. What about the bottom-up strategy? Bottom-up. They reach agreement among the players as to the form of self-government like in number one, like the top-down, but then they entrench these in the Constitution. This approach sounds good, but some Native groups are concerned that not all the players would be willing to sit down to reach such an agreement, as we have seen in the constitutional talks. Not all the provinces agree on the definition of self-government. Some say that approach is too political. Another approach is amend the Indian Act. Oh, just change the Indian Act and everything will be fine for self-government. Maybe it would give Indian people more power, but in effect it would be little change. Furthermore, it does not address the Inuit and the Métis concerns. Another option are specific agreements between representatives of Native groups and the government. Specific agreements. These agreements would replace the Indian Act, but would not appear in the Constitution. I will talk about this model next week with the Seashelt Indian Band to illustrate. It is a bottom-up approach, really, without constitutional guarantees. It raises the question, who has the power to change the rules of the game? That's a key question in political negotiations. When we look at political negotiations as a game of strategy, who has the power to change the rules of the game? And of course, there's also the court route. Court route. It's a time-consuming and risky option. Our friend and colleague, Professor Norm Zlotkin from the College of Law, who was with us last week, underlined this point rather well, saying the court route is costly, time-consuming, it's risky. If the court decides in your favor, you can negotiate, but if it does not, it will be much more difficult to get the government to devolve more power to your leadership. So the court case is really not one to favor. What are some of the federal policy options? Just like some changes took place in the land claims concept as expressed by Professor Cardinal in the first part this evening, there's also been some changes in attitudes in the minds of some of the politicians regarding the concept of self-government. In 1973, Trudeau established the Office of Land Claims, which was a departure from his 1969 position when he rejected the concept of Aboriginal rights. Trudeau, however, continued to refuse to enshrine any group's rights, let alone the Indians, that would take away the powers of the federal government, and that included Quebec. And you know the stalemate we're at in today in the Constitution. In 1982, the Trudeau government established Parliamentary Task Force on Indian Self-Government to review, and I quote, all legal and related institutional factors affecting the status, development, and responsibilities of band governments on Indian Reserve. To review the band government on reserves. This committee traveled across Canada and they heard about 567 witnesses. It produced a Penner report, 1983. I'm going to write this down. This is a very important paper. The Penner report 1983. I'm just mentioning it tonight. We're going to look at it in a deeper way next week. While I think of it, next week when you come, bring your paper on the seashell proposal that I wrote. You have that in your article reprints. Bring that with you in class, and you students in Videoland, bring it with you to class next week. That's what we will be dealing with. And the Penner report is at the very center of my paper. It's a paper that I did 4 years ago as part of my undergraduate, really, at UBC, and on the Seashell Indian Band proposal. So bring that paper with you, because we will be looking at it very closely to illustrate one model of self-government. Suffice to say at the moment that the Penner report strongly endorsed in 1983 the entrenchment of self-government in the Constitution. And it was necessary in order to fully protect these rights from arbitrary legislative and policy changes by the government. And as you know, the Penner report was not implemented, was not, like so many government reports and task force and commissions. The recommendations are not recommended. In 1984, Bill C-52 proposed that band government become essentially municipal government rather than a third order of government as proposed by the Penner report. 1985, Bill C-31, which we will see in a couple of weeks from now on women's issues, allowed band controls over membership, but not over the fundamental question of Indian status and entitlement. Bill C-31 allowed bands to control their membership, but not the status and entitlement. In other words, throughout the 1980s, there was much confusion within the government with respect to Indian self-government. Some politicians firmly believed in self-government for the native people, while others did not see self-government as a realistic possibility. And the result was another task force, headed by Eric Nielsen. Native leaders called that task force the Buffalo Jump Report, because it rejected self-government for Native people who were losing trust, once again, in the government. Let's finish this section this evening with the constitutional talks. The first part was definition, B, options, and now the constitutional talks. There were 4 major conferences: 1983, 84, 85, and 1987. And these conferences brought all the players of the game of strategy here together. Native leaders, federal government representatives, premiers of the provinces, to discuss Aboriginal rights, including the right to self-government. One of the goals of the Aboriginal groups at those conferences was to achieve self-government through constitutional reform and have their Aboriginal rights clearly defined and entrenched in the Constitution. I repeat, some of the goals of the Aboriginal group was to achieve self-government through constitutional reform and have their Aboriginal rights clearly defined and entrenched in the Constitution. Okay, let's look at the 1983 conference briefly. The guarantee of Aboriginal and treaty rights was also extended to include any future rights acquired by land claim agreements. The guarantee of Aboriginal and treaty rights was also extended to include any future rights acquired by land claim agreements. Professor Cardinal referred to this. This may prove to be very important for all Native peoples, not just status Indians, if self-government is indeed included in future claims agreements. The same was true for the 1984 conference. However, Alberta, BC, and Saskatchewan retreated from the government's proposal, saying they were not ready to commit themselves unless self-government was clearly defined. The 1985 conference, under Mulroney, proposed a statement which included both an affirmation of the right to self-government and a commitment by the two governments to negotiate the form of self-government. Wow. That would seem to be hitting the nail on the head. Hey, we got something going here. But then again, some provinces disagreed. We must remember that the requirement to make a constitutional amendment requires 7 provinces with 50% of the population. 7 provinces plus 50% of the population must agree on the issue to make a constitutional amendment. Saskatchewan proposed a new plan, which did not commit the two governments to negotiate agreements with the Aboriginal people. Imagine. You're talking about self-government for Aboriginal people and you don't even include them in the discussion. And Mulroney accepted the Saskatchewan plan, but the Assembly of the First Nations, of course, rejected it because they weren't seen as part of it, of the discussion. Just a political merry-go-round. While the federal government and the Penner Report, for that matter, and many of the Aboriginal leaders favored the top-down approach whereby rights would be guaranteed and the specific form of these rights and structures would then be negotiated, many of the provinces wanted the bottom-up approach where the rights should be negotiated by all the players. And that's the one that the Assembly of First Nations says, no, that's too political. It gives the right of the provinces to pull out if they don't agree. The result of the 1985 conference was nothing really substantial except for a clarification of positions maybe, and the recognition that Aboriginal groups were no longer going to accept the dictates of their ruling governments in designing their future societies. And that was made very, very clear, not to the government, but to all the people of Canada, that the Aboriginal people were not going to allow the government dictate to them the future of their societies. This was in 1987, at the last constitutional talk that ended in failure. The federal government in March 1987 seemed to be prepared to acknowledge inherent rights to self-government, as were several provinces. But again, BC, Alberta, and Saskatchewan, and Newfoundland argued there would be no such rights until they were negotiated politically. The bottom-up approach. Consent of 7 provinces, as I mentioned before, was needed to implement any amendment. You need 7 provinces plus 50% of the population to make an amendment to the Constitution. Furthermore, Quebec at that time had not signed a constitution, so their delegates were not even active participants at the talk. Mulroney headed an effort to reach a compromise. The premiers of the dissenting provinces refused to go along with it, and they argued that they were already serving the native people well within their own provinces. Something like Professor Cardinal alluded to, saying that Oh, why do the Indians want all these things when the treaties that we made with them provide them with so many things? Yeah. Once again, the existing government structure of Canada was upheld, reducing once again the chances of Aboriginal people to gain self-government entrenched in the Constitution. What we've seen here tonight really is only an introduction to the concept of self-government. I encourage you to read your required reading material, which will give you a background and complement what is being said in the textbook. And try and get a feeling about the difference between sovereignty and self-determination. Try and have a handle on what self-government is. It's not easy. What is the difference between an inherent right, as the Aboriginal people say, and a delegated authority? Next week, I will start by giving an illustration, a model of self-government, that of the Sechelt Indian Band. There are many others in Canada. There are strengths and weaknesses in all of them. And don't forget to bring that paper with you to class next week. Okay, that's it.